Okay. Good evening, everyone. Thank you for joining on the weekday. I know this is the informative session for who are all joined today. My name is Raja Kaskurte. I'm the TANA Community Services Coordinator. We are doing a lot of educational webinars to help the community, and we do a lot of immigration seminars also. This is one of the immigration seminar we are doing it today. Before we start, I would like to introduce Telugu Association of North America, TANA President, Mr. Anjay Chaudhary Laugaru, to say a few words about this as well as TANA. Anjay Garu, please unmute yourself and.
Raja, can you hear me?
Yeah, good.
Thank you, Raja. Good evening, everybody. And like Raja mentioned, I know the importance of time. I'll definitely say a few words. But as he mentioned, TANA does day in and day out almost a program a day, whether it's here or in India, to multiple platforms, whether it's TANA Foundation or TANA Cares or TANA Team Square. So we are always at the service of the people, Telugu people in general. But having said that, in that sphere of TANA Cares, we have to do multiple service activities, especially for the people residing in North America. And immigration forum or immigration webinars is one of them. So we have done a lot of immigration webinars in day in and out, almost, I could say, probably at least one in a month at an average. Whenever there is, not only we also do at an ad hoc basis, whenever there are new changes, we would be the first people to capture those and get it to the community. And this session, especially, on EAD and Green Card, and just now when Malikji was mentioning, there's a bonus also. There's some new change or policy, and then he would go through the highlights as well, even though it was not part of the agenda. So having said that, once again, I want to recognize Vinay Malik from BKM Law Group. Thank you. He's a host of today, of course, man of evening. So definitely, thanks a lot. Heartfelt thanks from TANA, Vinay Malikji. So looking forward for more collaboration with you and your law firm to help the people. As soon as any new changes come, we are there, and with us, you are there. So definitely, thank you once again. And then from TANA friend, Raja Kaskurte, just now he spoke. He's our community service coordinator. And in addition to Raja, we have Murali Talluri, who is our joint secretary. Both of them have, conducted or organized many immigration. In addition to both of them, we also have Sudhakar Katragad and Rao Voleti Garu, our immigration, ad hoc committee chairs. So once again, thanks to both of them as well. These four constitute our core committee for this. And of course, without the help of entire unconditional support of TANA leadership, this is not possible. So didn't want to take more time. So let me hand over the control back to Raja and Abhinayji. You all have a good session and good night.
Yeah. Thank you very much, Anjay Garu. Thank you for saying the nice words. And I would like to introduce Vinay. Before we introduce Vinay, I would also like to thank the entire TANA leadership, as well as who are the coordinators for this, myself, as well as Murali Talluri, Joint Secretary, and Sudhakar Katragedda. He is also Immigration Committee Chair, and Rao Venkatesh Voleti Garu. He is also Immigration Committee Chair. On the Immigration Forum, we do a lot of educational webinars and question answer sessions with different attorneys, different immigration attorneys. Every month, almost like every month, we do one session to help the community and create some awareness. And I would like to introduce Vinay Malik. He is from VKM Law Group, which is located in New Jersey. I would like to say he's an engineering graduate, like most of us here in the IT sector, right? We are all engineering background, but he came here and chose a path to get into law, and he got the law degree and he became immigration law specialist, and also like patent specialist, all those things. He can help, like he can answer more questions related to us also. Like he was like us earlier, so he can answer more things for us. I would like to introduce Vinay Malikji. Please go ahead and start the session. Vinay, yeah, it's all yours.
Okay. Thank you, Raja. Thank you, Anjay ji. Really appreciate the opportunity to reach a vast audience. And as Raja ji was mentioning, I came here I came to the US on an H-1B myself many, many years ago. Now I'm dating myself. But so I do feel the pain that most non-immigrants and immigrants are going through, because I was in similar shoes. I was in the same boat. And, I went through the process myself. Of course, at that time, I didn't know what was going on. And, now I'm in a position to help others. So I really thank God for that. And again, thank you, Radhaji and Anjayaji, for giving me the opportunity to speak with you all. I'm going to share my screen. And if you guys can't see it, do let me know. But I have a small presentation. Can you guys see my PowerPoint?
Yeah, we can see Vinay. Yeah, anybody have any questions? Please post it in the chat room. So once the presentation is done, we can go over the questions. And once the posted questions are over, we can open up for discussion. Okay, thank you all. Please go ahead, Vinay.
Okay, thank you. So today's topic, deals with employment authorization and interfiling updates. These are two pretty hot topics. Most of you have probably heard something about these matters. They're relatively recent, so we thought it would be a good idea to talk about them, and not at a high level, but also get into some details as to, what are the nitty-gritties for getting your employment authorization, and what are the details surrounding these interfilings, especially with the EB2 dates moving very, very quickly. So let's get into the presentation. Okay, so quick disclaimer. I'm sorry I have to say this. This presentation does not constitute legal advice. This is really for information only. We are not going to develop an attorney-client relationship between the viewer or listener and me or any member of VCAP Law Group. All right. So a little bit about my firm. I won't spend too much time. Radhaji has already done a great job in introducing me. We're a law firm based in Princeton, New Jersey. We focus on business immigration. And because immigration is federal law, we can really practice in any state. So, location really doesn't matter. And now a little bit about myself. Again, Radhaji has already spoken a lot about me, so I'll be quick. I have a bachelor's degree in electrical engineering from Mumbai. I have a master's degree in telecommunication engineering from RMIT, Australia. I actually came here on an H-1B, worked for about 5 years as a network engineer. And then I decided to go to law school, went to George Mason in Arlington, Virginia. And I've been practicing law for about 14 years now. And prior to that, I have 5 years of network engineering experience. But please don't ask me any questions about routers or switches. I don't remember much. So let's keep the discussion focused on immigration. So what will we discuss today? Work authorizations for H-1B spouses who are H-4 visa holders, work authorizations for spouses of L1 visa holders who are L2s, and work authorizations for E1, E2, and E3 spouses. They really don't apply to most people, but they can really be lumped together with the L1s. We're going to talk about interfiling a little bit. There is a couple additional slides about some developments that happened today regarding the potential expansion of premium processing and the decrease in processing times. I'll quickly hit those two points at a high level. We haven't had much detail and I haven't had much time to read the actual rule, but I just wanted to, touch on them before I open up for questions. And then of course, we'll have the question and answer round. So let's move on and let's talk about the background pertaining to the spouse EAD extensions. So how this all really came about was there was a lawsuit filed by a bunch of plaintiffs. The lead plaintiff was Amandeep Shergill. So that was Shergill v. Mayorkas is a case. Mayorkas is, the Secretary of Department of Homeland Security. It was a case in the District Court, Western District of Seattle. And really the litigation was about, unreasonable delays at USCIS for processing EAD cards. And as it happens a lot with these cases, before they actually reach a judgment stage, there's a settlement many a times. And in this case, USCIS or DHS decided to cave in, and they didn't want to go to trial because I think they thought they were going to lose anyways. So they came up to a settlement with the plaintiffs, and that resulted in the new policy guidance for EAD extensions. So I just want to give you a background as to how this all came about, because even with the current administration, sometimes it is good, or it behooves us, depending on the facts of the case, to actually sue USCIS. I've done that myself for some of my clients, and we've received very favorable outcomes. So there's something to keep in mind, for the future going forward. So H4 EADs, under the new guidance, which resulted from the settlement, an expired EAD can be used to extend up to 180 days beyond the expiration date. What does that mean? So if my H4 EAD expires on June 30th, 2022, if certain conditions are met, all right, I'll get an automatic extension for the rest of the year, right, from July 1st to December 31st. But what are those conditions? All right. First, I need to renew my EAD before my current EAD expires. And that's something people do anyways. Now, this is the trick. I need to have valid H4 status. Now, this becomes tricky. Why is that? When you file for an H4 extension, if your I-94 has expired in the interim, you can continue staying in this country, but legally speaking, you don't have H4 status. You're in a period of authorized stay, but you don't have H4 status. If that is the case, your EAD cannot get extended automatically, which is a bummer, but that's something very, very important to understand. And remember, as of now, we don't have premium processing for H4 extensions. So if you are concurrently filing for an H4 extension and an EAD extension, if your I-94 expires in the interim, you won't get the 180 days, right? Because somewhere in between, your I-94 is expired, right? So the automatic EAD extension is valid either until the new EAD is obtained, or if your H4 status expires, or 180 days, whichever occurs sooner. So it's not as helpful as people would have expected it to be. All right. So it's something to keep in mind. Now, if everything works out, right, you're still in H4 status, your EAD has expired, but you filed for an extension before the EAD expired, you then have an automatic extension. But some employers don't know how to use this in order to do the I-9 verification, which is very important, because unless the I-9 verification is done, you can't continue working. So what do you need? You need, for the I-9 verification, you need the expired EAD, right? The EAD card, which is expired. You need the renewal receipt notice, the I-765 renewal receipt notice. And keep in mind that the category on the renewal notice needs to match the category on the expired EAD card, which is C26 for H4 EADs. And you also need your unexpired I-94. All right, you need all these three documents for the I-9 verification. And all I-765 receipt notices that USCIS is sending out right now will have this notation, which really says that the applicant is eligible for automatic EAD extension. All right. It's a different case for L2 visa holders. Per the rules, employment authorization is incident to L2 visa status now. What does that mean? If you have an L2 visa, you don't even have to apply for an EAD. Just because you are on L2 status, you now have authorization to work. All right. Now, well, what if your L2 was approved before the settlement agreement or before this new policy came into effect, right? So USCIS is now issuing new I-797 approval notice with new codes. What are these codes? For L2 spouse, there's a code L2S on the I-94. If you have that code on your L2 approval notice, you're good. You don't need to apply for an EAD. Similarly, if you are entering the country on L2, CBP is issuing I-94s with these appropriate codes. So if you look at your I-94 and you see the entry code, instead of L2, it should be L2S. Now, I just had a client today that came in on L2, but CBP did not put in the right code on the I-94. So it's very important that you check your I-94 as soon as you enter the country. If you realize that CBP has not put in the appropriate code, you typically have 30 days to just call the CBP at whatever port of entry, JFK, EWR, and they'll fix it within minutes. And that's what my client did today. They came in through JFK. The I-94 showed L2 instead of L2S. I asked them to call CBP at JFK. I spoke with them at 9 in the morning. By 9:30, CBP had fixed the I-94 entry code to L2S. All right. Now, in cases where USCIS approved a case, right, before Jan 31st, an L2 case, L2 extension, with just the L2 code, they're actually sending amended notices with L2S. Okay, and the same thing for and the same deal with the receipt notices where cases are pending. They're sending amended receipt notices with code L2S. All right, so that's something to keep in mind. And so again, if you are the spouse of an L1 visa holder, meaning an L2 visa holder, you do not need to apply for EAD. Work authorization is incident to your status. So this is the result of the settlement agreement, right? H4 EADs and L2 EADs. Around the same time, what USCIS did is they came up sua sponte, meaning on their own. They also changed the policies for the spouses of e-visa holders. And their situation is really identical to that of the L2 spouses, right? Employment authorization is incident to status, whether you're an E1 spouse, E2 spouse, E3 spouse. No need to apply for EAD, and USCIS is issuing new I-797 approval notices with new codes, and CBP is issuing new Form I-94s with the appropriate codes, which in this case is E1S, E2S, E3S. Now, just yesterday, we received notification from USCIS that even if you were to enter on an I-94 where the code is incorrect, meaning if you're on L2 and you don't have L2S as a code on the I-94, they really won't care. You can still use the same I-94 for I-9 verification. I would still advise, however, that if possible, try and get your I-94 corrected. You just never know what your HR executive is going to do. You don't know if they know about this new change. So it's just easier to get the code corrected. You get the appropriate code, then there's no ambiguity, right? Now, some of you have also heard about the automatic visa revalidation program. This is where if your visa has expired, but your I-94 has not, you could go to Canada or Mexico and just re-enter the country, and get examined by CBP and get a new visa. Now, in that case, you may not get the new code on the I-94. But again, it really doesn't matter. But just keep in mind that if you go through the automatic visa revalidation program, where you go to Canada or Mexico, stay there for less than 30 days, and then try and come back into the US and CBP gives you your visa, the I-94 they give you may not have the new code, all right? So just keep that in mind. So now, let's talk about interfiling or transfer of underlying bases. Now, a lot of you have probably read about this. It's not something new, all right? Earlier, this procedure was called interfiling, and now it's called transfer of underlying basis, but it really means the same thing. What it means is if you have an adjustment case pending, all right, and obviously the adjustment case is tied to either an I-130 if it's a family-based case, or an I-140 if it's an employment-based case, and your life situation changes and you get approved for a different immigrant visa, right? So if you were an I-130, you then get a job, go through PERM, and you get an approved I-140. USCIS gives you the benefit of saying, you know what, I want to bet on a different horse, right? My first horse was the I-130, but now I like the I-140 horse better because it's stronger, it's galloping faster. So I want to move the I-485 that I had filed with my I-130 and then move it to my I-140, okay? Or if I had an I-140 approved under EB3, and I also have an I-140 approved under EB2, I filed my 485 with my EB2 I-140, but now the EB3 dates are moving faster, right? And my I-485 may get adjudicated sooner with an EB3. I can write, in all these cases, I can write a letter to USCIS saying, dear USCIS, please move my pending I-485 to this new immigrant category, all right? Used to be called interfiling, and now it's called transfer of underlying basis. What happens when you do that? It's a discretionary grant. USCIS will receive your grant, and then they're going to sit and think, well, you know, should I do this for Vinay or no? And there are a number of factors that might affect their as to whether they'll grant you, you know, the interfiling or no. One is, where's your file, right? Where's your I-485? What office is it in? How busy are they? That's another thing. How complicated is either one of your cases? If it's too complicated, if they can't retrieve your file, remember, a lot of these files are still paper files. Like doing, they can just deny your request for interfiling. Okay. Now, in that case, what do? Well, you always have the option of filing another I-485. USCIS will never say no to that. This is America. God bless America. You pay money. They love that. All right. So remember, that option always exists. Your option to file another I-485. Now, at any given time, they'll adjudicate only one I-485, but they'll take your money and both can be co-pending. All right. So what's this big deal about interfiling right now? So I'm going to give you guys maybe a 1-minute background about how visas are allocated, right? There's not an unlimited number of green cards, all right? There's always an annual limit of about 1 million green cards that USCIS has to allocate, right? From October 1 to September 30th of the next year. There are some categories where those visas have to be allocated first. What are those? Immediate relatives of US citizens, right? You know, spouse of a US citizen, parents of a US citizen, child of a US. These are all immediate relatives. First of all, they get all the visas, okay? They have about 400,000 of those. And then the rest are allocated between the different employment categories, right? EB1, EB2, EB3, EB4, EB5, with no more than 150,000 per category. But amongst the EB categories, the employment categories, if there is some extra number of visas, they're first granted to the EB1 categories. If there's any left over, they go to EB2. If there's any left over, they go to EB3, and then EB4 and EB5, right? What happened is, because of COVID, a lot of the consulates, US embassies abroad, were not operational. And most family-based green cards are awarded through consular processing. So you have all these visas that are ready to be given, but the consulates aren't working, right? Because of COVID. So now you have this a large number of family-based visas which cannot be used. So they got put into the EB categories, right? Into the employment visas. Now, You might say a bunch of people applied in October 2020 for EB3s when the EB3 dates are moving soon. So why don't you just give it to them? They've all been waiting for a long time, right? Because the dates retrogressed. That's not how the rules work. The rules say if there are extra visas, they first have to be given to EB1. If EB1 doesn't get used, they go to EB2. If EB2 doesn't get used, then EB3. So what happened was we got all these unused visas, EB3 retrogressed, but we really can't give the visas to them first. We have to first give the visas to EB1 and EB2 because that's what the statute requires. So USCIS says, wow, okay, and now they're looking at all the EB2 numbers, right? There are a whole bunch of approved EB2 I140 sitting, but the dates were not current. But now they have all these visas, right? And most of the people who use these visas are from India and China. So they're saying, they're literally begging us right now, please interfile, right? If everything works out, please interfile. Do it before September 30th, 2022. Why? Because that's the end of the fiscal year. And it's almost guaranteed that they will grant your request. All right? It's almost guaranteed. Yes, it's discretionary, but unless something is really wrong, right, they're going to grant your request, right? Now, the key, though, is, and I've highlighted it on this slide, the key is that your priority date has to be current. All right? You just can't interfile if you're allowed to use your filing date. Because the whole purpose, come to think about it, of interfiling is that they have a visa that's ready to be granted right now. So please interfile. Well, if your priority date isn't current, meaning if your final action date isn't current, they don't have a visa for you right now. The reason they're letting you file based on your filing date is because they're predicting that you will have a visa available, that they will have a visa available for your priority date within the next year. But it's a prediction. So they don't want to do it, they won't accept an interfiling request unless your priority date, meaning your final action date, is current. This is something that's very important. The second thing is there was some confusion where a lot of us, including me, we thought if you look at the policy manual that the person needs to be maintaining valid non-immigrant visa status in order to apply or in order to avail of the interfiling facility. USCIS clarified that and said that's not the case. So let's just say you file for your I-485 during the October 2020 filings, when the filing dates were current, and you file for EAD and advance parole, you get your EAD, and then you don't extend your H-1B anymore, right? So technically, you don't have valid non-immigrant visa status. USCIS has clarified and said that's not a problem. As long as your 485 is pending, right? As long as your I-485 is pending, you are in a period of authorized stay. You are working pursuant to your EAD. That's good enough for them. You can still apply for interfiling or transfer of underlying basis as long as your priority date is current. All right, so that's something that's very important to know. Now, some more points about this. As I said, approving the request is discretionary. Now, the fact that you have a pending, let's just say your EB2 I140 hasn't been adjudicated as yet, all right? Does that prevent you from filing your interfiling request? The answer is no. The existence of another pending I-140 petition does not matter as to the adjudication of the I-485 based on an already approved I-140. So you might say, Mr. Malik, does my EB2 I-140 need to be approved as of now for me to file place an interfiling request? The answer is no. It's great if your EB2 I-140 is approved, but let's just say for whatever reason you have a perm that's good to go, and you want to file for an EB2 I-140, right? And by using your prior dates, your final action date is current, you can still concurrently file for your EB2 I-140 and your I-485. Okay, so you file for I-140 and then you place your interfiling request saying, here's my I-140 paperwork, my firm, and everything. And by the way, I have an adjustment pending. Here's the receipt notice. Please move that adjustment case to this I-140. Link the two together. That will work too. In many a case, though, your EB2 I-140 is already approved. If that is the case, be sure to file I-485J along with your interfiling request. All right, because USCIS wants to make sure that your EB2 I-140 employer is still willing to give you your green card job. All right. As I said earlier, approving the request is discretionary. So, at any time, USCIS can say no, and they can point to, the policy manual, which says, hey, the request, we have every right to deny your request. My experience thus far, they're not doing that. They are desperate to allocate the visas. Why is that? There was a lot of litigation last year when I'm sure a bunch of you heard 80,000 green cards went to waste because USCIS just did not have the processing power to adjudicate those cases, and it put them in very bad light, and they just don't want to be in that situation again. So they're approving every request as soon as they can, to be honest. And how will you know that USCIS has accepted your interfiling request? They're not going to send you a letter. They'll just issue you a new receipt notice. Okay. And if you file I-485J, they'll issue you a I-485J receipt notice. So again, that's something to keep in mind. They're not going to write a special letter to you saying we've approved of your interfiling request. They'll just issue you a receipt notice. There is a centralized address to send the to send your interfiling request if you haven't already done that. I can share that with you. Just send me an email. I'll send it to you. The one question a lot of people have is, can we send our medical records with the interfiling request? And the answer for that is it's unclear. It's really unclear. USCIS has said do not send any other paperwork besides the letter and your I-485 receipt notices, your current I-485 receipt notices and 485J. They haven't really said whether they will accept or deny or reject any medical records. If you haven't sent your medical records already for your current I-485J, I say take a chance and send them over. Worst come worst, you do them again, but the last thing you want is them sending you an RFE for your medical records. And lo and behold, it's September 30th, 2022, and they no longer have any visas to give out. So I would say I'm advising my clients, if they're willing to fork out the $500-600, just send the medical records along with the interfiling request. There have been some there's just one more thing I want to talk about, the interfiling. Again, I've had a lot of people ask questions about this. So the portability. Portability is the provision where once your I-485 has been pending for 180 days, you can change jobs as long as it's a job in a similar occupation, right? So if you're a software developer, your 485 has been pending for 180 days, you can now switch jobs. You don't have to stay with your green card employer as long as it's another software developer job and not a project manager job, for example. If you were to use the interfiling request, your portability clock resets. All right, which means you gotta wait 180 days before you can change jobs from your EB2 employer. All right, so that's just the way it is. So just keep that in mind. Couple of things I want to talk about. This just happened today, and there's a lot of things that are going on from a policy perspective to try and improve backlogs. Just today, President Biden, in his budget request to Congress, He's asked for a lot of money for DHS. He wants to improve the functioning of the immigration courts. He wants to improve ICE's function. But more importantly for this crowd, he's proposed ramping up funding for USCIS from 400 million to 900 million. So almost double the funding, out of which $765 million will be allocated to reducing backlogs, processing backlogs. So that's a huge deal. Now, we don't know if Congress will give him the money, but at least that shows intent on part of this administration to do something about the backlogs, because there have been numerous lawsuits that we don't even hear about. I mean, that you may not hear about, but I know because I'm an attorney for delayed adjudication, right from H1s to EB1s to N400s, asylum cases, so on and so forth. And USCIS is just getting hammered with these lawsuits. And if the same judge starts seeing multiple lawsuits regarding processing delays, he or she is going to start thinking, wait a minute, there's something seriously wrong with this agency. Why are so many people suing? And in fact, one judge, USCIS said, look, our processing time is 10 months. And so we are within 10 months. And he said, you cannot compare snail space to a snail space, right? So if you're moving so slowly, that doesn't mean you're doing the right thing, right? 10 months shouldn't mean that shouldn't be the norm. So a judge actually said that, and all of us attorneys are now quoting that language in every lawsuit we file against USCIS regarding processing delays, and we're getting a lot of good response. But what USCIS is saying in these lawsuits is, wait, we just don't have the resources, we don't have the money. We try to increase our fees, which I'm sure you guys have heard about. You didn't let us increase the fees. We don't have people to do the job. As simple as that. So there's nothing we can do, and so now the White House is trying to at least increase funding so USCIS then cannot say they don't have the money to hire people and so on and so forth. So in that vein, there was a new development that happened today. USCIS issued an update saying that they are going to establish new internal cycle time goals. What's an internal cycle time goals? What you guys see online, is a processing time, right? You're all probably familiar with it. It says, I-129s, it's taking anywhere from 4 months to 1 year. And you might say, how can that be? And really the 4-month time is the time within which they adjudicate 30% of the cases. And 1 year is the time within they adjudicate 90% of the cases, all right? Well, if you're one of those people who are within the 10%, that really doesn't help you, because now it can take more than a year. A lot of clients have been questioning me about this. It's like, well, my friend got his green card, in 3 months, and it's been 9 months, and why can't I get mine? Well, maybe that friend got lucky. He was within the 3-month time frame, and you're the 10%, and you're not even going to be in the 90% time frame. So it was really messed up. So there's not much what we could do. But what USCIS has indicated is their internal processing times are going to get adjusted in such a way, meaning they're going to be a lot more aggressive in their internal processing time, meaning the times they've set for adjudicating different case times internally. So let's just say internally, if earlier an adjudicator was told, look, you have 9 months, all right, to adjudicate cases. Well, now he's being told, look, you only have 5 months. So obviously the processing times will improve, right? Because internally they have cut short the time they have available to adjudicate these cases. So they've established new internal cycle time goals. So for example, non-premium I-129s, their goal is to adjudicate them within 2 months. Okay. I-539s, 3 months. I-765s, 3 months. So let's see how it goes, but that's the announcement they made today. They are going to expand premium processing for different categories in a phased manner through the end of fiscal year 2022, which is September 30th, 2022. And in order to do that in a phased manner, they're first going to expand premium processing to other I-140 types. So right now, EB2s and EB3s were being premium processed. They're going to open up premium processing for EB13s, which is the multinational manager category. They're also going to open up premium processing for EB2 NIWs, which is the national interest waiver categories, which is a category that does not require a labor certification. And then from there on, they're going to expand it to I-539s, which is what we use for H4s and L2 extensions, amongst others, and then I-765s, which is the EAD extensions. Now, or EAD applications. I have to review the rule in detail to see what the premium processing fees will be. As all of you know, or most of you know, it's $2,500 right now. They might be increasing that. So I just have to read the rule to see what that is. I don't have that number right now. And the other thing they're trying to do is also increase the automatic extension periods of EADs, meaning right now, a lot of the automatic EAD extensions are for 180 days. They plan to extend that beyond 180 days. So your automatic extension might be for some time period more than 6 months. All right. Another thing they're doing right now is if you file for adjustment, your EAD is good for 2 years instead of 1. Earlier, it used to be 1 year. Now it's 2 years. So they're doing a whole bunch of stuff to try and, ease the pain on the non-immigrant and immigrant community. Again, they're constrained by budgetary factors and also that they can't take up so many categories under premium processing that the regular processing of other cases gets worse. They can't do that, right? So they need to balance this out. But hopefully the increased funding is going to help. So this is something that happened today. So stay tuned for more details, but I just thought I'll bring this up during this forum because it is very relevant to, I would think, a large portion of the audience. So that pretty much brings me to the end of the substantive part of the presentation. I thank you so much for your time. I'm gonna open up the floor to questions. I also have my contact information, which is on the next slide. Let me just see if I can bring that up. Yep, hopefully you guys can see it. That's my contact information, my email address. You can email me directly. That's my phone number. It's my office line, and you guys can feel free to contact me over here. I'll keep this slide open.
Yeah.
Yeah, and do we have questions?
Yeah, keep that slide open. So if anybody want to note down the email ID and the phone number, they can note it down.
Okay.
I have some questions here on the chat box, so I will read the questions. Maybe we can go one by one. If we have enough time, we will open for the open discussion also after these questions are answered. But we have a lot of questions here. Let's start with these things first.
Okay.
Hi, I have received my EAD and AP, but my I-140 amendment for company acquisition has not yet approved. Is it safe to travel India on AP?
Yes. It's safe to travel on AP as long as the card says it's valid for travel. I would just be careful that you don't want, I would keep track of my I-140 adjudication. I wouldn't want the case getting denied while I'm out of the country, because if the I-140 gets denied, then the 485 will get denied, and then everything else, falls through the cracks, right? The EAD and AP, everything gets revoked. So it's okay to travel, but stay in touch with your attorney and make sure that the I-140 doesn't go south. If there's an RFE, it gets addressed, so on and so forth.
Okay. When this new rule, expand premium processing, is going to affect?
So I need to look at the dates. I haven't looked at the final rule. I would say about 30 to 60 days from now. Typically, that's what happens once a rule gets published. The way agency rulemaking works, it goes into effect in about 30 days. They could reduce the date, if it's an emergency, but typically it's about 30 to 60 days. So I just have to read the rule. Again, I haven't had time to read it.
I think when it is fully cooked and you have more information, I think maybe we can do one more session on that particular thing about the premium processing topic.
Sure.
Okay. And the next question, what is the best way to get automatic H4 EAD extension for 180 days? Also, what is the eligibility criteria for that category? Automatic 180 days EAD extension.
Okay. What I would do is, first of all, make sure you're eligible for EAD. If it's an extension, you obviously are. It means your spouse has an approved I-140, right? Or an I-140 or perm pending for more than a year. Apply as soon as you can, right? Apply as soon as you can and make sure your H4 status stays valid. The underlying H4 status cannot expire, right? If that I-94 expires, your EAD will only extend up to that date. So apply as soon as you can. I advise my clients, apply for an H4 extension and EAD extension 6 months before expiration, which is the soonest you can, and then just hope for the best.
Okay. And the next question is, can we travel to India if H4 extension and H4 EAD under process? If we travel to India and get H4 stamping, then can we get auto extension of H4 EAD?
The answer to that is yes. The answer to that is yes, right? So you applied for an H4 extension. Now the wrinkle is, under the rules, if you travel while your H4 extension is pending, they can deny your H4 extension because you're no longer in status. But if you nevertheless get your H4 visa stamped and you come back into the country, that issue is resolved, right? So now you have valid H4, right? Maybe for 3 years. You already applied for your EAD, which is not contingent on you staying in the country, but you have your EAD extension receipt notice, hopefully, right? You have your expired EAD, right? And you also have valid H4 status because you entered the country on H4, right? Based on the visa stamp. So you should be eligible for an EAD extension. I mean, the facts of every case are different, but at eye level, I would say that works.
Okay. And the next question is, hi. Applied my I-140 in EB2 with priority date February 2013. I moved to new employer and filed my 140 in EB3. This happened last year due to favorable dates I applied in EB3. I came to know that I cannot do interfile because I don't have approved I-140 in EB2 with new employer. What is your recommendation? Should I stay in EB3 lane or should I start new EB2 I-140 process, which takes longer time?
If budgets were infinite and attorney fees were not an issue and everything, I would say try and get an EB2 I-140 if you can, right? Get your current employer to start the EB2 perm, and if they're willing to, that is, and kind of again, try and bet on both horses, right? and see which one is moving faster. I mean, it's very tricky. You never know what's going to happen next year. But if you have the resources, if you have a willing employer, then I always recommend, if you can, get an EB2 perm, if possible. The problem is these days, because of how the prevailing wage determinations are coming in, if you don't have a master's degree and you only have a bachelor's degree, right, it's going to be a level 4 wage for an EB2 perm. And so a lot of employers sometimes are now very reluctant to do EB2 perms for those having a bachelor's degree. So that's just something, I'm seeing in my practice. But again, if the stars align for you, I would say try and get an EB2 I140 approved too. So now you have 2 horses in the race.
Okay. The next one is USCIS announces new actions to reduce backlogs, expand premium processing, and provide relief to work permit holders. Okay, I think this one, when we have like more information about that, the new premium processing thing, we will do one more session, hopefully in soon. The next question is, does it minimize the visa bulletin dates for EB2?
Does it minimize? I'm not sure I understand that.
I think he posted that the news article from USCIS, that new actions expand premium processing, and he was asking, does it minimize the visa bulletin dates for EB2? I think his question is it going to reduce the dates for EB2 or something like that?
No, not really. I mean, the dates depend on how many people are applying and how many visas are available, right? Premium processing, I don't think premium processing is for I-140, remember, not I-485, all right? So from what I'm looking, the way I look at things, I don't think any of this is going to affect the visa bulletin per se, right? I think what it's going to affect is, the ability for some people to file more cases, right? But no, I don't think it's going to affect the visa bulletin, at least based on what my understanding. Now, again, I might change my mind once I read the rule, but I haven't read the rule.
Okay. And I think the question might not, I think it's not clear, but I will ask him to ask the question like when we are done with these questions in the chat room.
Sure.
Okay, sorry for asking more. This is my last one. If we travel, do we need to come back before current H4 I-94 expires? If we travel to India, do we need to come back before current H4 I-94 expires? I think the previous question was, I think he asked if they,
Is it a pending question, Raja? I'm sorry.
Yeah. I think he asked some question earlier, but he asked the question, can we travel to India if H4 extension and H4 EAD under process? If we travel to India and get H4 stamping, then can we get auto extension of H4 EAD? I think you already answered that question, but the extension to that question is, the extension to that question is, if we travel, do we need to come back before current H4 I-94 expires?
If you travel and it's 2 things, all right? If you travel, you need to be able to come here before your visa expires, right? Because you need a visa to enter the country. So that's the first thing, right? You need to, so that's like your entry ticket into the US, right? So number 1. Number 2, you obviously need, now if the visa expires 2 years from now and you enter the country, they're going to give you an I-94, which is coexistent with the expiration date of the visa. So that's that, right? Now, if you enter with a visa that's going to expire in 4 days, but you have a valid I-94, which is good for another 3 years, they'll give you a new I-94. The CBP will give you an I-94 that's good for another 3 years based on the I-94 you have. But the bottom line is, to enter the country, you need a valid visa, meaning an unexpired visa.
Okay. And the next question is, hi, this is Devi. My final action dates has been current last year, March 2021. It's like almost 1 year. It has been current. I submitted all the RFEs they asked for. Then in December, they changed online status to ready for interview. We will let you know with the notice. It's like 3 months now. I haven't heard back anything from them. My GCEAD and driving license is going to expire so soon. So please suggest what to do in my case. How can I get my green card ASAP?
Okay, so first of all, make sure you apply for your EAD renewal, right? I mean, you have a pending 485, you should be able to apply for a renewed, to renew your EAD. Do that. And then based on that, you can get your driver's license extended, number one. Now, I don't know if this is a marriage-based case or an employment-based case. I don't think the person who asked the question has indicated that, right?
Oh, no.
No, okay. Almost every marriage-based case gets interviewed, all right? A lot of employment-based cases are not interviewed, but some are. Unfortunately, if this is an employment-based case, this lady got picked for an interview. So depending on the field office, right? Some field offices are slower than others in scheduling interviews, because remember, the interviews are done at the field office, right? Not at the service center. And the field office that has jurisdiction over you depends on where you live. So I would look at the processing times for the 485 at the field office that has jurisdiction over where this lady lives, and see whether you're within those processing times or no. If you're beyond that, then I would raise a service request and try to figure out what's going on.
Okay. So the best option is they have to apply for the EAD, the GCEAD, as long as it's in the pending state. So that's the best bet to do it.
Yes.
So, yeah.
Yes.
Okay. Can we switch company if my PD is February 2015 for EB2?
I don't have the visa dates right here in front of me, so I can't answer that question. But if you file for your 485, okay, and if your 485 has been pending for at least 180 days, you can change jobs as long as it's in the same occupation or similar occupation, right? But I wouldn't switch jobs if I haven't filed for my I-485, because in my experience, if I switch jobs, then the employer who got the I-140 approved, why would he support my I-485? Because you need to file I-485J.
Okay. And the next question is, can we switch company? Oh, okay, sorry, I read that. Interfile versus refile of AOS. What is your recommendation?
Good question. It really depends on how badly you want your AOS to be approved within a certain amount of time. If you have an approved EB2 today, and if you're willing to take the chance that USCIS, for whatever reason, will deny your interfiling request, which I doubt, but it's possible, then you just interfile. If, on the other hand, you don't want to take that chance, right? For example, you're in EB3 retrogression. I'm just giving an example. And your child is about to age out, right? Your child is about to hit 21. So you're running into a Child Status Protection Act issue. Well, then just file under I-485, pay the extra fees, because you really need to have filed for your I-485 to stop the clock on your child aging out, right? So it all depends on your personal circumstances.
Okay. And the next one is, any chances of EB2 retrogress?
Not for this year. I doubt it. Again, I cannot predict. I'm not, I don't know. I don't have visibility into the Department of State's, working, but I have a feeling it won't retrogress, at least until September 2022.
Okay. And the next question is, my first time H4 EAD expedited request was refused. Will it impact the normal timelines?
No, not really. Not really. They just refuse to expedite it. It's still being processed in the normal processing time. Yeah.
Okay. My PD is October 2016, and I am planning to change the employer. Please let me know what you suggest.
Yeah, again, I don't have the visa bulletin in front of me. I can't, I've given my high level answer to, changing jobs. But this is a case specific question, and without the bulletin dates and everything, I can't really answer that question.
Okay. And the next question is, downgraded to EB3 I140 approved and received EAD AP but not used still on H1. With recent changes in dates, planning to refile in EB2 with new I485, for which we will expect EAD/AP sometime in the future. After filing, leaving the country and entering with EAD AP that was received with EB3, what will happen to the refiled EB2 I485? Is this a valid scenario? What are the risks and consequences?
If you travel while your I-485 is pending, okay, you can do that if you use your H1 or H4, okay, not a problem. If you have advanced parole that's valid, that's still good too, okay, as long as you travel within the validity period of the advanced parole. The fact that you now have another I-485 pending, that's okay. It's just that you have two I-485s, right? And you're using the advanced parole from one of them to travel in the country. Where I would be very cautious if I withdraw the EB3 I-485, which was linked to that EAD AP, and then I try to travel on that AP linked to that I obtained based on the EB3 I-485, which is no longer pending, that'd be a problem. So I'd be very careful about that.
Okay. My EAD date is current. My question is, after we apply, if the date retrogresses back, then will it impact my EAD processing?
You mean green card processing, right? Not EAD, because EAD there's nothing about.
I think I don't know, they put my EAD processing, but
yeah, that question, I can't parse through it. I mean, if what they're saying is, can you just repeat the question, Raja? Sorry.
My EAD date is current.
Mm-hmm.
My question is, after we apply, if the date retrogresses back, then will it impact my EAD processing? I think it's a GC, green card, I guess.
Yeah, obviously, if your dates retrogress, then they're not gonna, and if your priority date is no longer current, they'll keep your I-485 on the side. They won't adjudicate it.
Okay. And the next question is, my wife is here on H4. My GC process is still pending, I-140. Due to COVID situations, my wife has initiated a transfer of visa status from H4 to F1. Right now, it's been more than 12 months. Do you think it's best she wait or travel outside the country and get the visa stamped outside? Please suggest.
So green card is pending.
Yeah, I think he's saying like she was here on H4 and GC process is still pending. Due to COVID situations, my wife has initiated a transfer of visa status from H4 to F1.
Mm-hmm.
Right now, it's been more than 12 months. Do you think it's best she wait or travel outside the country and get the visa stamped outside?
Yeah, a lot depends on what is it that she's trying to do. Does she want to study? or does she want to, be on H4, right? I mean, again, I don't know the facts of the case, but my general advice to clients is if you can help it, stay in the country. If you can, then you go, because there's this doctrine of consular non-reviewability. Okay. What that means is once you go abroad and you go to an embassy, and if your visa gets denied, it's very difficult to fight that denial, right? As opposed to a denial from USCIS. So if you can help it, just stay here unless you really have to go.
Okay. Downgraded to EB3 from EB2 and received EAD, but 140 is still pending. Is it safe to change employer on EAD? If yes, what are the things to be make sure?
The I-140 is still pending.
Yeah.
Wow, that's a tough situation to be in, because when you filed for your I-485, it was based on an I-140, and the I-485 is linked to the concurrently filed I-140. If you leave, will your employer continue to support the I-140 petition? If not, that I-140 may get denied, or they might revoke it. If they revoke it, the I-485 also gets denied. So you really got to be very careful about this situation. I would talk to my employer and explore options. I mean, it's conceivable that you tell your employer, look, I want to quit, keep my I-140 going. If it gets approved, and then it's time to get the 485 approved. If USA has asked, will you still have the green card job offer open? If that's all good, yeah, change on your H1. But I would have a very serious conversation with my I-140 employer.
Okay. I interfiled. It's been 2 months, but no response from USCIS. Now I am planning to refile and send new 140 I-485. Does this impact negatively to my case in any way? What are the pros and cons of refiling?
Pros is you'll get a receipt notice relatively quickly. Cons is you're going to spend money, right? As I said, interfiling is discretionary. They won't really respond to you. They'll just issue a new receipt notice. Or they may not even do that. So unfortunately, it's a black hole. And if you don't have the wherewithal to wait, then file again. And then if you find out that the interfiling was successful, you can withdraw the I-485 you filed after that, right? Because that's superfluous. But the money you spent is gone down the drain. You're not getting that money back. So it all depends on your ability to wait and your ability to spend.
Okay. And the next question, can one work on 1099 with EAD instead of W2 while 485 is pending, or should there be W2 job?
No, 1099 is fine. You can start your own company, yeah.
This is for the primary applicant, that's what.
Mm-hmm.
Okay. I want to check if both husband and wife dates are current. Is it recommended?
Oh, wait a minute. Let me just.
To apply
this is
both
the primary
separately
applicant.
to
Sorry, can you just go back to that
or
question?
just apply from one and wait for other in case first one reject? What would be the attorney fee for filing 485?
Sorry, Raja. I'm sorry. I was just thinking about that question again. This was a primary applicant, right? Can you just?
I think they both husband and wife. They both filed separately. I think I'm assuming it's employment based separately, and both of their dates are correct. And what he is asking is.
Raja, I can't hear you. Hello?
He joined back. Maybe he left.
Oh, okay.
Hi, would you like to take a question?
Meanwhile, I have a question. Can I ask a question?
Sure. I mean,
Yeah, okay. So I have an employer like I work for a bank in Atlanta. They filed the green card and unfortunately they laid off almost 35 people. I was one of that. So they get severance package, everything that is good. But at that time my I-140 is in progress. Like they've completed the form, but they didn't share the I-140 details. So, but I have a form with the date is there. Is it possible to use the date technically, to get the priority date? Because I don't have 140 priority date, right? But I have a 2016, I have 140 priority date. So is it possible to put the 2012 with the perm, the date for no?
you need the I-140.
So that is a must, right?
Okay. I'm sorry about that. I think I lost the connection. So let me.
No problem. Yeah.
Hey, Vinay. Yeah, this is Ramana. I think he was referring to my question previously regarding the primary applicant. So my wife is family-based, and I'm the primary applicant. So I was just wondering if I can work on 1099 rather than a W-2 job.
No, you're the primary applicant, employment-based.
Right. Yeah. I already completed my GC interview and all. I'm just waiting for the decision.
Just wait, man. Just wait. Don't do this. Yeah, just wait. Just get your green card. The reason being is if you quit now, remember, green card was a job for the future.
No, I'm not going to quit. Can I do both W-2 and a 1099? That was my question.
Oh, so you're not going to quit your job?
Right. Yeah.
You're going to do W-2 plus 1099.
Correct.
It's a double job kind.
Okay. I understand what you're saying. And you want to use your EAD for that?
All right. Yeah, I have some issues with my H-1 employer, so that's the reason I'm planning to use my EAD as a trump card.
No, wait. So for your I-9 verification with your H-1 employer, did you use your H-1 or EAD?
H-1, that was with H-1, and I recently moved to my primary vendor with my EAD on a W-2.
Then you already are on EAD.
Right.
And you're on W-2. Wait, I'm a little confused. Let's talk offline. This is very complicated because I see a whole bunch of issues over here, and I'll need to understand your case better. So,
okay. And the question I was.
Sorry, quick question. See, once the 140 is applied, is it allowed the H4 dependents to travel India?
Yeah, I mean, if they have an H4, they can travel at any time. It's not
okay. Okay.
As long as they have a valid H4, right?
They have a valid H4. Yeah.
Doesn't matter.
Thank you.
Okay. And the next question is, I think the question I was asking, if both husband and wife dates are correct, I think they both have employee-based the filing. Is it recommended to apply both separately as two applications, or just apply from one and wait for the other in case first one rejects? Like, what they are asking is that they both can apply at this moment. I think with the different 140 or whatever the current state. Is it recommended to apply both separately, or they can apply both together, like as a wife and husband or something like that?
I would. So again, every case is different. But here's the thing. The rules say that you have to apply for your green card within a year of your date becoming current, okay? Barring exceptional circumstances. If I were them, I'd apply separately and put each other as a derivative, okay? So now you've got your own, green card, you've got your wife's green card, you're on your own, you're on your wife's, and vice versa. whatever gets approved first gets approved, and then you withdraw the other.
Okay, and his question is again, and the next question from the same person is, what would be the attorney fee for filing 485?
Yeah, I don't want to discuss fees on that.
Yeah, I think you can reach out to Vinay on the phone number he provided. Maybe he can provide the details of those. Okay, do you suggest to move to H1B from H4 EAD status, or do you foresee delays in H4 EAD even in the future?
Again, this is a very personal question. Difficult to answer. I cannot foresee. Look, if I could foresee everything, I wouldn't be sitting here. I'd be betting in the stock market, right? Or something. A lot depends on your personal situation, really. Is your employer willing to support your H1? Obviously, you're tied to your H1 employer, then you can't switch jobs that easily. So it all depends on what is it that you want to do. In terms of processing delays, look, the current administration really seems committed to reducing processing delays. But remember, administrations change. We all know what happened 2 years ago. We could come back to that 2 years from now. So again, I think just look at your personal situation and do what you think is best for you.
Okay, and could you please advise if more than one perm can be filed for an individual by different employer at the same time? One is with EB3 and the another one is with EB2 category.
You can have multiple perms. That's not a problem, except one employer will say you're working for them, the other employer on the perm will say you're not working for them. But you can have multiple perms. It's two separate positions.
Okay. And my filing date is current in EB2 category based on the April bulletin that was released a few days ago. When can we start filing for I-485? Also, do you think if there is a chance that these dates may get retrogressed? Also, when I file my I-485 now, can I file 131 and 765 couple of months later, as I currently have a travel plan in July?
So you can file for the I-485 along with your I-140, right? If your filing dates are correct, or basically you can apply for I-485. Do you have to file for EAD and advanced parole at the same time as I-485? No, you can do that separately. Will dates retrogress? That's a very difficult question. A lot depends on how many people interfile, how many people file. I can tell you that when the EB3 dates, filing dates, came up, I predicted there would be a retrogression, and it happened. It's really difficult to say. A lot depends on how many people file now that the filing dates have moved up so much. They could retrogress, but my whole thing is if you can file now, you should just file. If you can file right now, you should.
I have a lot more questions. I just stopped the chat. So whatever the questions we have it in the chat box, I will read it now. I think the time is almost like 9:30. So we will see like how many questions we can answer from the chat room now. And if anyone have any more questions, you please reach out to Vinay. If it is a simple question, he can answer. If it is not, maybe you can consult him how to proceed. Okay, I will finish these questions. The next question is, the priority date got current in October 2020, and they all applied. Then, wife and kids got GCs, but not husband. Is it common that one family member gets GC and not another, or is there anything concerning?
So did the primary applicant get the GC?
Yeah, the wife is the primary applicant. So wife and kids got the GC, but not the husband. Wife is the primary applicant here.
It's just a matter of luck sometimes. It's very difficult to say unless they found something in the husband's history which they did not like. Again, this is a very fact-specific thing, right? Were there any criminal convictions? So it's very difficult to answer that question. I've seen some cases where one family member gets left behind. It's just pure luck. There wasn't anything wrong in the history of that file. So this will depend on the facts of each case, right? So I haven't looked at the husband's file, so I have no idea if there was something in there that would prompt, that would cause an issue in the adjudication. So yeah.
So is it like, do they have to wait some more time and then raise the service request or something? Or?
Yeah, I would look at the processing times and then raise a service request the moment you're out, because it's very weird because typically what happens is when a file gets adjudicated, when a primary applicant gets adjudicated, the derivatives get adjudicated at the same time, right? Now, I don't know if the husband filed later.
Okay.
That could be a case too. So it'll all depend on the facts of the case.
I think what they mentioned, they all filed at the same time. So
same time.
Yeah.
So yeah, I would just wait for some more time and I would raise a service request and see what's going on.
Okay. The next question is, can we do a consular processing from India under EB3 category if date is current? What are timelines for getting green card? Yeah,
you can do consular processing. Absolutely. It takes a good, in the good days, pre-COVID, we'd say 6 months, post-COVID, longer. So you just have to be ready to wait for a while for the consulates to get you in for an interview.
Okay. And the next question is, my spouse's employers allowed to work even her EAD expired and H4 is not approved. We will have any legal issues?
Yeah, lots of legal issues.
And the continuation of that one is, we got receipt notice for both H4 extension and EAD. They allowed based on this.
They shouldn't have. If the H4 has expired, they can't. They cannot.
Even though they have the receipt notice.
Yeah, it doesn't matter because you need to have valid H4 status for the EAD extension, 180-day automatic extension. So it looks like that the spouse doesn't have a valid H4 status. Like the extension is pending. It's not approved.
Extension is pending. Yes.
Yeah, it won't work.
Okay. A lot of people say get Margarita visit to Mexico to renew H1B. Okay. Is that true?
I need a margarita right now.
A lot of people say get Margarita visit to Mexico to renew H1B. Is that true? Do we get stamped at airport without going to embassy? I plan to visit India and no Dropbox slots available. So I want to get H1B extended visiting Mexico.
Yeah, that a lot of people are doing that. In fact, I've heard of package deals. There are some enterprising people who have created these packaged tours or package deals where, you pay them and they make sure they accommodate you and then they bring you back to the border and all that. So that's happening. Sure. It's what I talked about, the automatic visa revalidation. AVR.
Is that true? Do we get stamped at airport without going to embassy? Is that true?
Yes.
Okay. Okay. And my priority date is March 28th, 2012, EB2, current final action date now. Trying to file I-485, but unfortunately, visa got I-94 gap as follows. My H1 file was missing and it went to Dakota Center instead of Vermont Center and reapplied. Then approved H1B, but here missing I-94 duration from May 2020 to July 2020.
It's fine.
Up to days are missing. After that, issued H1 extensions and got approved until 2023. Shall I go ahead and 485 filing, or else go back India and get stamping and get new I-94? Please suggest.
So the gap in the H1 is 2 months, correct? Did I get that right?
Yeah, 52 days. 52 days. I got it missing. Is a file is North Dakota. It went instead of Vermont. So my attorney is saying that I cannot file 485, you had to go back to India and get stamping, get new I-94. So, please suggest me, can I go back to India or?
Wait, but your H1 was a non-proton extension approved?
Yeah, approved. 2.5 years I got approved and I got a valid visa I-94 right now.
So you were not asked to leave the country for consular processing?
Yeah. They didn't because I'm working currently and I am paycheck, I have it. But that 52 days got H1 file was missing and returned back. 2025, 2020 to 7/15/2020. 52 days without I-94, without H1. I stayed in United States.
So typically anything less than 6 months of unlawful presence is something USCIS will waive that in its discretion for adjustment. So,
but after that, I got H1 extension, but I got current filing green card is 2012, my priority date. Now filing date is came. So there, my attorney is not moving forward because of this 52 days gap. I got it.
yeah, I mean, every case is different. I mean, I haven't looked at your file, so it's very difficult for me to provide a legal opinion over here.
Yeah,
but
I got a tracking number, is a FedEx, whatever FedEx tracking number. It is returned back to attorney and everything I have evidence right now.
No, that's okay. I understand that. I think what I'm trying to say is,
yeah, this critical.
Yeah, the adjustment rules say that anything less than 6 months of unlawful presence is not an issue.
Okay.
All right. Now, if there's something else in your file that I'm not aware of that your attorney knows, and that's a different story. So again, I cannot give you a definitive answer. Your attorney knows your file better than I do, right? But I'm just telling you what the general rule is.
But this duration is 50 days. 52 days is missing, and as well as is paycheck. We employee didn't run the paycheck. That is a cause of is going back, or paycheck he didn't run it in during that period because I don't have a valid I-94. Valid H1 is not get it. Receipt number we didn't get it actually.
Right. So you accrued unlawful presence for sure, but it's less than 6 months. So that's something USCIS can, in its discretion, waive during the adjustment adjudication, is what I'm saying, if that's all the issue is. But again, I don't know your file that well. So this is something you should consult. You have to share your file with an attorney, with another attorney for that person.
I will communicate tomorrow. Direct with you. I will forward to you. Yeah. Thanks, Vinay.
Yeah.
Okay. And the next question is a question on visa Dropbox appointment. Is there any new rule to get visa extensions for parents before submitting the kids' documents? Earlier was allowed to submit all applicants at once. Now, hearing it has to be separated for kids. Please let us know.
Yeah, I don't know how the embassies are doing things, so that's something you'll have to look at the web page there. That's not something I do all the time.
Okay. My date is current in EB2, but I downgraded to EB3 in 2020. Since my downgrade is pending, can I interfile?
Yes. I mean, the rules say you can. I mean, the latest memo says you can.
Okay. After receiving green card, can we switch to new company immediately, or is it mandatory to stay 6 months?
Good idea to stay for 6 months, because when you're naturalizing, they might ask you, look, if you quit the job right away, then that really wasn't a job that was available. That wasn't a job. That wasn't a bona fide opportunity because you quit, right? So I would recommend stay for 6 months. Remember, and this is for everyone, your journey doesn't end when you get your green card, right? Your immigration journey ends to some extent only when you get your citizenship. So you have to keep your nose clean until then, right? No felonies, and and a whole bunch of other things that could cause you to get deported. And one issue is this: You don't want to quit your green card job right after you get a green card, because then that shows that you never really intended to take the green card job. So I would suggest stick around for 6 months. You've stuck around for years. What 6 months? Just stick to it for 6 months, and then you can quit, so that there are no issues during a naturalization.
Okay. My spouse on L2 and never had EAD from 2019 September. We are in US and now we are filing for extension. Do we need EAD to be applied?
No.
I'm not understanding why my attorney is preferring refile versus interfile.
Well, it depends on the facts of the case, right? So
I think that he asked the earlier question. His date is current in EB2, but I downgraded to EB3 in 2020. Since my downgrade is pending, can I interfile? And the continuation to that question is, I am not understanding why my attorney is preferring refile versus interfile.
So there might be some other facts about this case that I'm not aware of, right? For example, there's a child who's aging out. Remember, interfiling is still discretionary. It may take them a long time to come back with, whether they're going to approve it or not. If they don't approve the interfiling request, there's nothing you can do. So if you want surety, and I don't know what your reasons are, right, to interfile, then maybe that's why the attorney is saying, look, just spend the money, file a new I-485 and keep it clean. So again, it all depends on the facts of the case.
Okay. And the next question, I think I have received green card recently. Can I apply green card for my brother and in-laws, or should I wait to get citizen and then apply? I don't think green card holders can sponsor the green card, right?
It depends. There are very few categories. You can sponsor your spouse. You can sponsor your child as a green card
Saying
holder.
like my brother and in-laws.
Yeah, well, you can never sponsor your in-laws. It has to be a blood relationship. Your wife has to sponsor her parents. So I don't do a lot of family immigration. I don't think you can sponsor your brothers or sisters unless you yourself are a US citizen. So you'll have to look at the categories, right, to see whether any of them fit into a category that a green card holder can sponsor.
I have valid I-94 and EAD L2 till October 2021. And I have applied for extension in July itself and got notice of action stating categories of automatic extension. My attorney said that I can work after October with that notice of action. So did I? So I did, as I didn't get my EAD and I-94 at that time. I got L2 status extension and EAD in February 2022. So would that be a problem as I worked after October? I want to inform that now I got I-94 from the day status expired, EAD expired, that is October till May 2022.
Yeah, there's a lot in here. I can't answer that question right now. I'll have to look at the dates very carefully, look at the approval codes and all that stuff. So, this is something we'll have to do a separate consult on.
Okay. This is KP Sompulli asking. He applied for citizenship while his application is in process. Does he can travel out of country? If no, what is the process, please?
You can travel while your citizenship is pending. That's not a problem. You just don't want to be away for too long. You don't want to give up your residency. So I don't know how long he plans to travel for, right? Certainly not for more than 6 months, I'm hoping. And you want to make sure you don't miss your biometrics appointment or your interview date.
Okay. 2012, my employer laid off 35 employees. That time, perm was filed, but not 140 filing. Can I use the perm date of 2012 December as priority date to port it now so that I will get my GC since dates are current for both EAD and file?
I think I answered that question. To the best of my knowledge, the answer is no.
Okay. I think he asked.
Yeah.
Okay. I have applied for EB3 downgrade during October 2020 and received EAD. Currently planning to interfile as I have approved EB2 I140, which is current. My question is, can my H4 high school daughter use the EAD we received with EB3 downgrade petition? Will that affect the process? Does that also mean she will lose H4 status?
The H4 status is dependent on the H1 status. If you do the interfiling, the EAD should still work, right? Because you still have a pending adjustment. Just don't withdraw the 485, right? If you withdraw the 485, that's a problem. Or the 485 gets denied, that's a problem. Then the EAD goes away.
Okay. And the next question is, my H1B application didn't picked up for 2022 lottery this month. Is there still chance to get picked up later this year?
Yes. So at least, well, there's no guarantees. But if what has happened in the last 2 years is holds true this year, to USCIS will conduct another lottery later in the year. In fact, last year it conducted 3 lotteries. So there is still a chance, if you look at, if your attorney or your employer looks at your status, if it says submitted, then it means that it's still in play in case another lottery is done. Now, whether another lottery is conducted depends on how many applications were picked, how many actually end up filing the petitions, how many get denied, so on and so forth. So there's no guarantee, but at least over in the last 2 years, ever since this electronic registration has come into effect, USCIS has conducted multiple H1B cap lotteries.
Okay. Has the rule come up which says no EAD to be filed for H4, or still EAD need to be filed?
Yes, EAD has to be filed.
Any chance of EB3 dates moving soon?
Doesn't seem to be that way. I think right now the EB2 dates are moving a lot quicker than EB3 dates. Difficult to predict again, but I think this trend will continue until September. But again, I can't predict.
Okay, yeah. I have approved 140 from previous employer and current employer 140 pending. If priority date is current, can my current employer still file 485?
Sorry,
I got the approved 140 from the previous employer and current employer 140 is pending. And if the priority date is current for the approved 140, can my current employer still file 485?
So if the priority date is current for the previous employer's I-140?
I don't know. I think, can he file the 485 with the pending 140?
You can, if your dates are current.
I think that's the question. I think with the current, yeah, they can file, right?
Yeah, if the dates are current, yeah.
Okay. And I am on TN visa. After filing for 485 with pending 485, can we travel on Canadian passport out of USA without advance parole?
I don't advise that, because a TN visa is not a dual intent visa. So the fact that you have a pending 485 is not good enough. You need advance parole.
Okay.
It's not a dual intent visa like an H1. And in fact, I don't recommend TN visa holders to travel outside the US until the green card gets approved, because TN is a non-immigrant intent visa, right? So now you're trying to come back in. They might say, wait a minute, you entered on a TN visa and then you decided to, get a green card. You might have some trouble at the border, but certainly don't travel without advance parole.
Okay. Thank you. And those are the questions in the chat room, but I have 2 people raised their hand. We will answer these 2 also and then end the session. Sorry for that, Vinay, but it's taking long time.
No problem. I'm here to help. Anything I can do, please.
Okay. Harish Shankar Garu, please unmute yourself. Harish Shankar Garu.
Yeah, Cheshan Raja, Cheshan.
Yeah, Harish Shankar Garu, please go ahead and.
I think I already posted the question.
Okay, that was already answered, right? I saw your hand was raised, so.
Before that I raised my hand, but you answered it. Thank you, Raja. Thank you.
Thank you, Andy. And the next question is from Ravindra. Ravindra Garu, please unmute yourself.
Hi, Raja. Thank you. I live in Michigan, Detroit. So Canada is border to me. So I have valid I-140 and valid H-1B document I-797 and a valid I-94. Can I travel to Canada for the stamping?
No, not really, unless you have a Canadian visa. See, that's where Mexico is a better destination. For Canada, you can travel to Canada for stamping, but you need a Canadian visa to enter Canada. You don't need a Mexican visa to enter Mexico if you're an H1.
Oh, thank you so much.
Okay. Okay, that's the next one is from Kedar. Kedar, please unmute yourself.
Thank you. It was a very nice and very informative session. Thank you very much, Vinay, for your time. I just wanted to know how, maybe that's a question for Raja, how we will get the recording for this?
Yeah, this is already live on TANA YouTube channel. If you go to TANA YouTube channel, you can subscribe and you will get all the alerts. And also we will share the whatever the YouTube channel link in all the groups again sometime tomorrow as part of our news bulletin.
Really helpful. Thank you.
Okay, and if you want, you can go to TANA YouTube channel anytime, and it's already it's live streaming there.
Sure, we'll do that, and I will subscribe to. Thank you.
Thank you very much. And Satyajit, please unmute yourself. Satyajit.
Yeah, hi. Thanks for the opportunity. Actually, hi Vinay. I have a generic question. Actually, I got my EAD by downgrading to EB3, and now that EB2 dates are more favorable, I'm current in EB2 as well. So I just have a question that if my dependent uses the EAD, will it impact in any way for me going forward into EB2 line, or will I be stuck into EB3?
No, you can interfile. I mean, if you want to interfile, you can. If you want to file another I-485, you can. It's no big deal.
Okay, thank you so much. Yeah.
And the next question is from Nagesh. Nagesh Garu, please unmute yourself.
Hey, hi. This is Nagesh. Thanks, Vijay, for your time and addressing all these questions. My quick question is, I have an approved 140 with my current employer, and my priority is March 2014. So it is current for EAD filing. And my current employer is not willing to file 485 now. He says you need to wait for 6 months for any reason. So I'm wondering, what are my possibilities to file 485 myself?
So your I-140 is approved?
Yeah, I-140 is approved.
See, the issue is you gotta file for I-480. You gotta file I-485J, which is the supplement, which shows that the job offer is still valid.
So if I do it myself, I need to submit a J supplement?
Yeah, you have to, right? Because it's based on your employment-based petition, right? It's not a green card.
I'm currently working with the employer.
So if they're willing to sign I-485J, then you're fine. I mean, remember, your employer never applies for 485. You as an applicant do, okay? Legally. Okay. It does that along with your application on form I-485, you got to file I-485J supplement, which has to be signed by both you and the employer.
Okay.
So if looks like your employer doesn't want to sign it, from what I understand. But if
it sounds like, yeah.
So yeah.
And my previous employer already have an approved 140. So at any time I can move back by transferring my H1 to him and file it, right? That's an open gate, right?
That's an open gate. In fact, you don't even have to transfer to that previous employer. You can just file the I-485 based on that I-140 if they're willing to sign I-485J. Remember,
I mean, the transfer is H1. I need to do a H1 transfer. Right?
Oh, okay, that's what they want you to do. That's fine.
Yeah. Yeah, thank you, sir. Appreciate your time.
Sure.
And the last question, and this is the last question. I hope nobody will raise the hand after this. So, yeah, please go ahead, Srini.
This is Mrs. Srini.
Hi.
I have a question with my H4 I-94. My H4 I-94 was renewal for the December 2020. I applied for renewal, but I couldn't go for biometrics since I had a lower back injury. So I couldn't go for my biometrics, but my son attended for the biometrics. And I requested for my reschedule of biometrics, but I didn't receive any. I was waiting like I would get letter from them, but I didn't get. After like 6 months I waited, I didn't know the rules. Then I contacted USCIS and then they sent me approval for me and my son. It has a gap of almost like 8 months.
But after that approved.
I got approval. So that gap of 8 months is there in my I-94 and our GC is current. So can we go ahead with filing that?
Well, when you say that, I'll have to look at your file. Because if your case wasn't denied, you were in a period of authorized stay, even though your I-94 had expired. Do you see what I'm saying?
Yeah.
Right?
Receive date in my present I-94. Receive date is from the date when my previous I-94 ended. But valid date
I need to answer one question. Hello?
Valid date is from August to until 2023. So there's a gap. So yeah.
Yeah, I'll have to look at the dates, very, very clearly. Because if your case wasn't denied,
yeah.
Yes, it won't.
I'm sorry.
Yeah, it won't deny.
If it wasn't denied, then you weren't accruing unlawful presence. You were in a period of authorized stay. But again, I'll have to look at the actual dates. I can't keep track of them in the.
Right. I understand. Okay. Yeah. Yeah, I'll give an email with that. Thank you, sir. Yeah.
No problem.
Okay, and I hope please nobody raise the questions. This is the last question we are answering. Okay, and then the question is from Vijay. Vijay, please unmute yourself.
It wasn't denied and all.
Hi, Andy. This is Vijay Ravi. Thank you for conducting this session, and all the information is really useful. So I have a very quick question. So my 485 got approved last October, and then I also attended the interview, in-person interview at the USCIS Center. The interview said everything looks good, and you should expect your card to be mailed within 30 to 60 days. So I waited and I received no update, and then I contacted the USCIS. They said you have to open a ticket. So I also opened a ticket, and still I have no update. So what should I do from here? It's been like 150 days past the interview happened.
And what does your online case status show?
It says the interview was over or finished something, and we had to take a decision.
So they haven't approved your case?
Yes. I got the I-485G approved also.
No, that's different. That's
okay.
They just approved the 485G. So they haven't really approved your case.
Yeah, but the interviewer said your case is all good, and I asked, like verbally, she said you're good. Within 30 to 60 days, you should expect your green card.
Okay, I would contact couple things. Open a ticket.
Okay.
And then I would. Can you hear me?
Yes, sir. Yeah.
Okay. Open a ticket and then wait for 30 days.
Okay.
And on the 31st day, contact the USCIS ombudsman.
Ombudsman?
Yeah. Contact them and tell them what's going on. Also contact your congressional representative.
Okay.
And if none of this works, hire a lawyer and file a lawsuit.
Oh, okay. Lawsuit. Okay. So these are the only options.
Yeah. I mean, unfortunately, sometimes lawsuit is what it takes. And remember, in a lot of these cases, you won't go to trial. Once you file the complaint, they'll just approve the case unless something is wrong, right?
Okay. So I had to do all these options and see what will happen at the end with the lawsuit.
Yeah.
Okay. Awesome. Okay. I will check on these. Thank you for your update.
I think Harleen Bashan, I think she was trying to ask the question. Please go ahead.
Yes, I was trying to ask, I had applied for green card. I'm a citizen. For my sister, she came in 2018. But the thing is, she has not come back in 4 years. You think her green card will be still valid if she comes back from India?
4 years.
Yes.
I'm going to share some anecdotal experience with you. Okay.
Okay.
Pre-COVID, they would have not let her in, I would think. Right. Post-COVID, though, things have changed a lot. Okay. She has a couple of options. She can apply for a returning resident visa at the embassy. They're likely going to deny it. The other option is just take a flight and show up at whatever airport. I would pick JFK or EWR. They might put her through secondary inspection. Okay. And then she should attribute at least 2 years to COVID. And then come up with some plausible explanation for the other 2 years. All I can say is it's worth taking a shot. The world has changed, ma'am. CBP officers are a lot more lenient because of COVID than they were 2 or 3 years ago.
Yes.
That's all I can say. But again, it's there's no sure shot way of getting this fixed. I think taking a flight and coming to JFK or EWR is a better option than applying for a returning resident visa at the embassy. But it's finally your call.
Okay. Yeah, it's all a chance she has to take, because she did not get her physical green card in hand because she had to pay that fees. She had that, when they put a stamp for green card, when they come to this country, and then she had to go back because her husband passed away. Even he had a green card, but he's gone due to COVID. So in 1 year, you can come back on that stamp, right? They let you in.
The stamp is 1 year. Oh, she doesn't even have a green card.
No, in her hand. It was lost in the mail somewhere. So that's what I'm trying to say. 4 years she could not come. She thinks I took her green card, and after 1 year I told her to come back, but she didn't. Then COVID started,
Yeah, I mean, it's the facts don't look very good, but these are the two options she has.
Okay, we will try with that. Okay, thanks. Somebody said that if she contact the USCIS, you need that permission, and then you have to pay 1,100 fees. We should go that option or just show up at the airport?
Well, that's a returning resident visa option, right? That I mentioned.
Okay.
So just look at both options. The returning resident visa is an application made at the embassy, not with USCIS.
Okay. But right now she's at Canada with her daughter, and I told her that just to come from the border, and we might, with that stamp she has. If they allow her, they allow her. If they don't allow her, then probably her green card is gone. Then they might not give it to her, because it has been more than almost like 3.5 years now.
Yeah, so it's a chance,
Yeah, I know. There's so much you can also advise us and do, but I should not pay that 1,100 fees because to take the permission. We don't know.
That's another option. But if she's in Canada, what does it take to go to the US border and take a shot at it, right?
Yes, sure. I will tell her then.
Okay, thank you. And this is the last question. I'm sorry to say that, but even though somebody raised the hand, I am not going to ask. So I am very sorry because it's too late in the night. Amulya, please unmute yourself and ask your last question.
Hey, I just want to know, like, I got the priority date is 2011, and I changed my employer, and then the new employer I did last 2 years back. They started my green card process. Currently, my perm status is still pending. It's been more than 8 months now. So the question is, like, how long does it take to? I already contact attorney, but they did not give any correct information on that. So how long does it take to get the perm approved since my priority date is already reached?
I mean, the perm doesn't have anything to do with your priority date. Remember, perm is with Department of Labor, right?
Yeah.
So when you say you applied for the perm, I'm not even sure whether you applied for the perm 8 months ago or you did the prevailing wage determination 8 months ago.
No, the prevailing wages was already done last year, and they did the perm in July 2021.
So it's taking about 6 to 8 months for an initial adjudication. And maybe if there's an audit, it's even longer.
Okay.
So it really depends,
So in the DOL website, I was seeing like the audit and the review. So review was going on September 21, and the audit was around June 21. So what's the difference between the audit and review there?
Review is the initial review they do. Audit is when they review it and then think of it as an RFE. Okay. Where they then say, you know what, we need some documentation before we can actually approve the case.
So what is an estimation like as per your side? Like how long does it take to get? It's already been 8 months now.
Yeah, I mean, and audits can take a long time. Audits, if it goes into audit, it could take another 6 months, right? There's a lot that can happen. The case can get audited. It can be sent for supervisory recruitment. So it's difficult to say. I would say be in touch with your attorney and keep asking for regular updates, but know that not everything is in your attorney's hands,
So when they will raise a query, like it's already been 8 months, so does it wait for 3 more months to raise any inquiries?
It could. Again, every case is different, so it's very difficult for me to say. I would say, again, I'm just giving you estimates, guidelines. So the guideline says minimum 6 months. Audits can take a lot longer. So every case is different. I would say be in constant touch with your attorney.
Okay. Thank you. Thank you for this opportunity. I really appreciate it.
All right.
Thank you. And people are still raising hands. I am sorry to say that we have to respect our attorney's time as well as our time also. It's been like 2 hours. We are sitting here and answering all the questions. Please understand our situation also. And Sivaram Krishna Garu, please go ahead with if it is a simple question.
Yeah. Let me ask my question. Thanks for the session. It's very informative. And my question is, so my wife has H4 approved and H4 EAD is in progress. So can she travel to India while H4 EAD is in progress? And if she needs to get stamped, is a H4 approval copy sufficient, or does she need to fill DS-160 also?
She can travel via EAD is pending. She does have to apply for a visa using DS-160. And then what she will do is she will provide her H4 approval notice as well, right?
Okay.
If she wants another visa stamp. So I presume she doesn't have a visa stamp, like she doesn't have a valid unexpired visa stamp right now?
Yeah, she doesn't have the valid visa right now, but the H4 approval copy we have.
Yeah, but she still has to apply.
DS-160, right? Okay. And one more question. So while H4 EAD is in progress, the primary can switch the company, or will it impact anything for the H4 EAD?
It really shouldn't, because you will still have an H1. Just don't go out of status.
Okay. Okay. So, okay.
Yeah.
Got it. Yeah. Thank you.
And the next, Seren, please go ahead.
Yeah, thank you, sir. Thank you, Vinay. It's all good informative session. One quick question. So I have the file for downgrade, EB3 downgrade and waiting, and my EB2 is current now. So I'm trying to file interfile request. But my question is, can I change the company location? Because my they have it in Atlanta as well. Currently, I'm in Boston. Can I change the company location right now, or are any restrictions until this process goes on?
The I-140 is approved, correct?
Yeah, EB2 I140 is approved, but that's on the Boston location, not on the Atlanta one.
Oh, Boston versus Atlanta.
Yeah. Currently, the EB2 is approved with Boston location, but I have filed a EB3 all downgrade also from Boston location. Now I'm trying to interfile with EB2 because it's current. Should I wait for this to play out, or can I change location right now, or is it tied to that 140? How does it work? Does it have any implications? Is it even possible to relocate at this point?
Let me ask you this. Will the green card job be in Boston or Atlanta?
Currently, it's in Boston. The same job they can offer. I can just change the location. I'll be working the same team, but we have two locations. I can go to the Atlanta location and work as well.
No, let me ask you my question again. All right. You're on H1B, right? Correct?
Correct.
The green card is for a separate job. All right. For that job, there was a perm file where you did recruitment. Right?
Correct.
Recruitment was done in Boston, correct?
Correct.
My question to you is, will your green card job be available in Boston or no? Let me answer that question for you. It has to be in Boston.
Oh, it has to be in Boston. Okay.
Why? Because the recruitment, the labor market test was done in Boston.
Okay.
Right? The ads were run in Boston, correct?
Correct. That's correct.
Like the work location on the perm was Boston, correct?
Correct. That's correct.
And Atlanta is too far from Boston. If you were within the same MSA, that's a different story.
Okay. All right. Okay. All right. Thanks.
Okay. Thank you all for coming to this. And also, I would like to appreciate Vinay Malik from VKM Law Group, and also all the TANA leadership. If you guys have any questions or anything like you want to discuss with attorney, please reach out to Vinay. He will be happily assist with you. So please note down his number and the email ID so you can reach out to him on his office hours, I guess. So Vinay.
Yeah, thank you so much for your time. I know it's late, but hopefully this helped. Please email me. It's better than phone calls, so please email me if possible, and then I'll try and respond to you as soon as I can. I mean, I may not be able to respond within an hour, as you can imagine, but I'll try and respond as soon as I can.
Okay. Thank you, and have a good night, everyone.
Right. Good night.
Thank you.